Good evening, everybody. Welcome back to another week of Reasonable Doubt, brought to you by the Harris County Criminal Lawyers Association. I'm your host, Jimmy Ardwan, along with my co-host, Julio Vela. Julio, your prediction skills stink, my friend.
This is Julio Vela saying.
Yeah. You tried to predict a win for our horns, and
Look,
see what we got, man.
Any day that I'm sitting next to Staci Biggar and I cross some Jimmy Ardwan is a good day. I'm just telling you.
Thank you, Julio.
Our guest this week, ladies and gentlemen, Staci Biggar. Staci, thanks for joining us.
Thank you for having me.
Good to have you here. Good to have you here. It is another week of election fun. Another debate is down. We have the elections coming up. Everybody here at this table obviously is focused on what's going on in Harris County with the judicial elections and our upcoming DA election and how it's going to affect us. And so we're paying attention to that. We'll talk a little bit about that tonight towards the end of the program. But, we're going to talk about some other good criminal justice programs for the next hour with Staci. We'll be taking your calls starting around 8:30 or so. 713-807-1794 is the number. We'll also take your questions via Twitter at HCCLA_TV, so you can shoot us your questions and comments right there. Interesting story coming out this week, guys. It was covered by the Houston Press. Big article yesterday. It's now come out in the Chronicle as well. The Texas Indigent Defense Commission recently completed an audit here in Harris County. And this kind of coincides with this bail lawsuit that we've been discussing and the bail reform. And no big shock, the articles and the commission found that poor, mentally ill, they're disadvantaged in Harris County courts.
Shocker.
Who would have thought that that would be their findings? But they had a lot of detail that they went into in terms of how it went so far as people, and this is stuff we've discussed on this program with a variety of different lawyers, that if somebody was able to make bond, they would then have the court-appointed lawyer taken away from them, which is just crazy. It's insane, and we've all seen it happen. We've all seen it happen. We've all been there. And I don't do court appointments at the state level. I know both of y'all do. And I do court appointments over at the federal courthouse. And so I want to get just from an initial impression, you guys reading this article, having lived it for so long, what are some of the things that came to y'all's mind when reading this report?
I mean, I think that I'm kind of in a different position because I predominantly work a lot of specialty courts, and so
Right.
I have contracts with the court. So I don't necessarily put my name in the wheel and do court appointments on a daily basis. I work a lot of programs. And so I'm kind of in a different position in that I work with judges that are probably more sensitive to the mental health issues. I do see it on a regular basis because I'm in the general courts. And you are right. I mean, it's the kind of the practices. If you are given a bond, then, or you do make bond, then you do lose your court-appointed attorney. I think that in our situation where we have more of the specialty courts, if you make bond, you keep that same attorney because that's our program. That's the docket that we run. So, and like you were saying, I mean, you do see on a regular basis a lot of the new judges, a lot of the judges, more my peers, I guess, aren't necessarily saying this. You make a bond, you're done. They are looking to say, well, fill out the affidavit, let's look at your circumstances and so forth. So I do see some change in that, but I do think that that is the standard practice still.
Do you think that for individuals who are, let's say, dealing with mental health, do you think that there are a lot more individuals in the jail who are dealing with some sort of mental health who aren't receiving maybe the programs or the opportunities that they maybe should get?
Well, okay. Well, first of all, the Harris County Jail is the largest mental health facility in the state of Texas. 25% of the Harris County Jail has some sort of diagnosis, has a mental illness. So obviously, even though we try to continue to implement programs, to look at jail diversion, to do those sort of things, that large population isn't going to have things available. In my opinion, a lot of that is educating the defense bar because the defense bar is usually the first people that deals with them, the first people that talks to them. You have a huge range of representation in the defense bar. I mean, you can get a court-appointed attorney that is very knowledgeable and can get you a bond and can get you hooked up with services and so forth. You can have retained attorneys that have no idea. You have retained attorneys, the same. I think a lot of it depends on the individual and who their counsel is. I will say that we're starting a new program, the reintegration docket, and so it's supposed to be a broader docket where bonds are pretrial bonds are going to be looked at more so. That's low-level felonies. It's going to be drug cases, third offender theft cases, and third or fourth offender prostitution cases. So I'm hoping that you'll see kind of this pretrial bonds and services and things like that to a more general public than what we've had in the past.
Do you think that what Staci Biggar is talking about is this new reintegration court?
Correct.
And do you think that, let's start with the bonds, because there's a lot of things I'd love to talk to you about. Do you think that more pretrial bonds will be given to individuals that maybe have criminal history in their past, or is it something that's going to be limited to first-time offenders, kind of no history kind of individuals?
I think that from what I've been told, Devin Anderson came and spoke with us yesterday. My understanding is that their office is going to be looking at people who maybe have been in the system before, maybe there are multiple misdemeanors.
Sure.
You know, there are people who maybe have had a felony before, but not anything too egregious. And those sorts of people are going to be looked at about making pretrial bonds. What I think is pretty interesting, and this all starts Monday, so we'll see how this all works out. I'll talk to you in 6 months or a year and let you know if the program's still working. But what they're looking at trying to do is trying to actually grant the pretrial bonds before they ever make it over to 1200 Baker. And so they're looking at trying to actually give them bonds and have them screened by pretrial. If they meet qualifications, then they would make bond from either HPD or they would make bond from the outlying county jail that they would be in. Now, it's only the Sheriff's Department and HPD right now, but, you know, the goal is in the future you would keep those people from ever hitting
the jail. Okay, so I'll ask you a two-part. Do you know how they plan on doing that? Are there going to be like some sort of screening procedures upon entry into the city jail, or Yes,
there's supposed to be screening procedures, and if pretrial can verify all the information, then they would make a pretrial bond from there. I mean, obviously, then, you know, it's and I do think that it's part of the lawyers asking. I mean, I go to court all the time, and I mean, you go to court all the time. You know, we watch lawyers never ask for it.
Right.
You're never going to get anything you don't ask for, and so so once they come to us, then we will look at them again, try to get further information, because a lot of times the reason that you can't get the pretrial bond is they can't verify where do you live. You know.
That was my second question, and so because a lot of the times we can't, or the individual can't come up with the 2 phone numbers or verifiable addresses or things. Right, because their phone's locked up in property.
Right,
and
exactly.
so has that been talked to, or do you know anything if that's been addressed?
Oh, well, I mean, I don't know if they're going to get their phone. But I mean, you know, but the thing is, okay, so the way that it's supposed to work, and I have a very limited.
Sure.
It hasn't started yet. Like I said, talk to me in 6 months or a year, and I'll tell you if it worked out. But the way it's supposed to work out is that once they come to us, then hopefully we can help get more information about them and then see if they qualify. So just to kind of go back, it's supposed to be a 3-track program. So 1 track is for pretrial intervention. One, and I'm kind of getting off the bond topic, but
No, it's
okay.
perfect. This is fine. We're already talking about reintegration. We'll get
Okay.
back to the bond, but
So one track is pretrial intervention, one track is deferred adjudication, and one track would be state jail track. So and then if you were, if you wanted to fight your case, you wanted a motion to suppress, you wanted a jury trial, you wanted all those things, then that case would go back into the wheel, and it would go to whatever court the wheel caught it.
let me go back. I want to make sure I heard it. So we have one for pretrial intervention and then one for a state jail track. What was the other one? Oh.
Deferred.
Oh, it deferred.
So the first track is pretrial intervention. The second track is deferred adjudication, and the third track then would be state jail.
What would, so let's break that one down. Why would someone get a pretrial intervention versus a deferred if, let's say, they're both dealing less than a gram? Is it the background?
It's going to be the background for the most part. And so what I've been told, and I'll see if this actually takes place, is that they're going to have, they started earlier this year a possession of controlled substance pretrial intervention program.
Right.
This is going to be kind of an extension of that program. So if you, in kind of the same criteria, so if you had previous misdemeanors, which you know that if you've had any kind of arrest, you wouldn't get a pretrial intervention at all in a misdemeanor or a felony. So this is supposed to be a broader pool of people that would qualify for that pretrial intervention. So because this is going to be a more intensive pretrial intervention or probation, you need to give the people an incentive, right? So yes, you may have had some misdemeanors. Yes, you may have had some previous issues in your life, which is what has led you to this point, but we can keep you from having a felony on your record if you'll participate in this program.
Now, but with all the issues going on with Precinct 4 and all this, I'm just I have a little reticence about these pretrial intervention programs because, are they just going to shuffle people in? What happens if we have another evidentiary issue with an arresting agency? They're talking about doing these pretrial intervention programs where they're screening people and basically putting them on from the get-go.
But you have to agree to it. I mean, it's not like you're going to say, okay, well, I'm going to force you. There's nobody that's going to force that person to take a pretrial intervention or to take a deferred adjudication or to take a state jail case when maybe they were TDC, because you would have to accept responsibility for that then.
Exactly.
So if you aren't going to accept responsibility for that and you want to have a jury trial, I mean, I'm never going to tell you, no, you can't have a jury trial. I mean, so then, or, I might see a case and say, you have a great motion to suppress here. Well, there's no way we're going to do this. Yeah. This motion to suppress needs to be handled. And, and so what's supposed to happen, I don't know yet.
Yeah.
But what's supposed to happen is that we would do all of our discovery at that point. So as the attorney for that case, we would request and do all the discovery to a certain point and prepare that case for a motion to suppress. Then that case goes to the wheel and to another appointed attorney.
But isn't the pretrial intervention program premised upon early acceptance in?
Okay, there's actually like 4 tracks.
Okay.
So you go, supposedly, I don't know.
Right.
Supposedly, I will get 5 people on Monday. I go and I talk to those people. Because what I do, I spend an inordinate amount of time talking to people. There are lawyers, and that's one of the things that we talked about and saw, is that there are lawyers out there that take 750 cases a year and they get them through and so forth. I don't know anybody that's working this program on the defense bar that is that type of attorney. And so the initial day, the initial meeting with them is long. It's you talking to them. It's you being patient with them. It's you trying to help them. It's you trying to advise them. And I also see, and you could probably say the same thing, is that many people go in the current system that we have and they take a probation that first day to get out of jail.
Exactly.
Not because they want help. this is a situation that's different. If you can find a stable place for them to be that's safe for both of them and the community, then they can make the decision if they want a pretrial intervention or if they want a probation. They're not doing it as their ticket out.
Sure.
They're doing it because they've decided that they need help or they need more to make their life, to get their life back on track.
Yeah.
So
Fair enough.
Are there, so for the individuals who can afford a lawyer, generally, not all the time, but for the lower level offenses, they may be able to not only afford a lawyer, but also bond out.
correct. And so they could still stay on this program,
Okay.
even if they bond out of jail and even if they have a retained attorney. So there's nothing here that's keeping them from having the lawyer of their choice. They'll still be eligible for all the same benefits that the program would allow them to have. They would just have made bond themselves and hired their own attorney.
Do you think that for the individuals who are indigent and declared indigent, and they very well may have some history,
Like criminal history.
like some criminal history, including some other prior similar offenses of either prostitution or
Had to.
state
You would have
state
four.
jail facility, or
You would have had 3 thefts.
less than 3 thefts or less than a gram, who maybe they don't qualify or their addresses or phone numbers don't check out. Those individuals, do you think that it's those individuals that will primarily benefit for the program, or do you see others too? Because my concern is that those people who still can't bond out aren't going to be able to bond out, and they'll still be going to do a pretrial intervention or a deferred adjudication in the hopes to get out. Do you see that happening, or do you think that those individuals very well may either get a pretrial bond, even though maybe some of their info doesn't check out, or at the very least, their bonds will actually be reduced to something that they can actually make?
And that is part of it. I mean, they are talking about doing bond reductions so that they could actually make the bond. But I do think that if you're going to fit into that category, even if you weren't in the program and you were in your regular home court, you still wouldn't have made that bond.
Right.
You would not have been given opportunities that you're now being given. You would have just said 1244A or state jail.
Right.
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 So I think that at least they're giving other alternatives
Right.
versus just jail. And even one of the things that we're talking about is, for example, and it's trying to encompass all. So you're talking about veterans, mental health, drug addiction, all the whole gamut, human trafficking, all bunch of different areas that could be part of the reason why you're continuing this conduct. And so one of the things even that we've discussed briefly is that if you did go the state jail track, for example, you have the Stars and Stripes program in the state jail.
Mm-hmm.
So a lot of attorneys, their client may go get state jail time, do whatever, but they're done.
Yeah.
They're not thinking about how could you help benefit this person, even though they are in the state jail, even they are in prison. If when they come out, have they given opportunity to change?
Yeah.
And so that's one of the things is like trying to work with, okay, even if they get that, can we put them somewhere where they can get something that would help benefit them so they wouldn't be back in the situation that we're in? So I know that there's going to be a lot of flaws with this program. I know it's not a perfect program. I know that we're going to, like I said, talk to me in a year. We'll see where we are. But it's change.
Yeah.
It's at least somebody trying to do something different than what we do every single day down there.
I want to go back to the mental health aspect of this because
Sure.
you said the same thing that everybody that has come on this program has said about the Harris County Jail, whether it's Ed Emmett, whether it's Kim Ogg, whether it is any number of defense attorneys,
Right.
whether it is political activists, whoever has been on this program. We all know the standard line. The Harris County Jail is the largest mental health institution in the state of Texas. Mm-hmm. And everybody says it. Everybody's ashamed of it. But nobody does a damn thing about it.
I don't know that I can really do anything about it, but
No, I know, but what I'm saying is,
But you can.
I'll do my best, I
you
promise.
can.
and I'm not suggesting that you can do anything about it, but from the political standpoint, one of the things that struck me about this article is, you know, and
The
let's
one
set
about the
aside,
bonds, or which article?
yeah, the just about the Indigent Commission, you know, and aside from the whole whatever political things there are that they can do to change this, what struck me, because I was even unaware of this, mainly because I don't do a lot of mental health cases, was that they noted that a lot of the attorneys who are being put on these cases are unaware of this law, that if a person is released on a personal bond, they're required to be,
If a person can be released to mental
health.
health program,
then they should be released on a
then
personal
no,
bond.
they shall.
Yeah,
They shall be. It's a shall.
right.
So, and yes, many people don't know that.
Wow. That's the law?
That's the law.
What,
That's the law.
But
what,
here's the
what's
sad
going
part.
on then?
Well,
You're not asking for the pretrial bond.
I asked for the pre-trial bond. I
You
asked
asked
for the
for the pre-trial
pre-trial bond.
no, but
I'm just saying.
you're not. But that's the thing, and so that's my point, is that lawyers like me who don't do that, you know, I would have no reason to know it because I'm not down there. I'm not doing these things. But what I find so offensive is that the courts are appointing lawyers who should, you know, if you're going to appoint somebody or you're going to take those appointments, you should know the frickin' law.
Right.
You
It's a
should
very
know that.
obscure portion, but yes, you should know that.
But I mean, like the cases that I do on a regular basis, you learn the obscurities.
Right.
That's what you do. And if you
I knew
are,
that law, for the record.
I
And
know
I
you
get
do.
'em out.
I know you do. But that, and that's
Where,
what
where
is
they,
it, but all you have to do is ask.
do it a lot in the
point,
Constitution.
point the judge to the law. I mean, that's what you're supposed to do as
But-
a lawyer. You're supposed to say, Judge, here's the law. It says you shall release them, and here's why.
if it's, so where are they being released to though?
So sometimes, so I'm going to give you like a misdemeanor example, right?
Okay.
So sometimes with the misdemeanor, and it's not all the time, but sometimes with the misdemeanor, what you can do is you can work out where if you could swear out an affidavit saying they were a danger to themselves or others, or we've also had times where we were able to work with the Harris County Psychiatric Center. We could be able to find a place for them where they would then be placed on a pretrial bond. They would go to the Harris County Psychiatric Center, and it's not like, I mean, it's not a super common situation. But you could then put them in, you know, if you can swear out the affidavit and get them there, then they'll put them on a pretrial bond. Precinct 1 transports them from the jail to the Harris County Psychiatric Center, and then they're there for pretty much acute care. But you at least have them there, have them stabilized.
Right.
And then once they're stabilized, you then need to find some sort of placement, doctors, and so forth to continue that treatment that they had there.
So let me ask the old question of, you're at your client, and you're the offer is a time served on a misdemeanor.
Okay, well, you're asking somebody who really believes in
See,
treatment, and
and
so
right, and so
I will tell them, I will relay that to them. However, I will push the other side of that.
and that's sure for sure.
Because I really do believe that it's in the best interest of my client for them to become stable. What I've also found is in scenarios like that, quite frequently, if we can get them back stable in the community, to a point where they're independent, not as independent as they can be, and doing well, I can get the case dismissed.
That's the next question I was going to ask you. Is
Especially
that
on a
something-
misdemeanor, not necessarily always on a felony case,
Right.
but on a misdemeanor case. On a felony case, you know, quite frequently we've done kind of informal pretrial interventions. I will say the mental health division of the district attorney's office is very good about working with that. Unfortunately, they don't necessarily have a misdemeanor division, so it's convincing the court and so forth that this can work and will work.
Right.
But what I would also tell you is that it makes you not just be a lawyer, but it makes you be a social worker sometimes. And a lot of people think that that's not part of their job, and so they won't make those connections and services and so forth so that those things can take place. Right. So the law is there, but there's a disconnect between who do you contact to make that happen. and I do. I'm the lawyer. I mean, you know, so sometimes I'm like, I think I'm a lawyer. Am I a social worker? I mean,
Well,
but that's what you have to do to get the client to that point.
and the hard part about it is a lot of those, unless you really have a passion for it like you do, you know, we're not really trained for that.
No,
We're not trained to take on that role.
neither was I.
But it's something that you obviously, like you explained to Julio, you know, you believe in finding the treatment and getting your client. So I mean, you've taken the role of the lawyer, and because of your passion for it, you've taken it to another level. The thing is that a lot of lawyers, you know, you're just not trained for that, and so it's like, I don't want to get into that area. You know, I don't. One, I'm not qualified, and I don't know that I'm the right person to do it.
Right.
And so I think that's the hesitation there with a lot of lawyers, and I can't say I blame them because, you know, unless you really do want to get into that, and I would imagine there's some sort of a learning curve too with how to
Huge.
balance
Right.
being a quasi-social worker and a lawyer at the same time. You know, that's just a different skill set to some degree.
Right.
Is there a reason why it's just for felonies?
What do you mean? Oh,
The
the bond?
reintegration court?
Well, okay, so back to the reintegration court. The reintegration court was basically looking at they did a lot of research on reoffenders. They did a lot of research on what was the population that was reoffending over and over and over again. And what they were finding was people who took 1244A, people who took state jail time, they would come back on multiple occasions. People who, and because pretrial intervention hasn't really been available a lot, there's not as much information on that, but people who had taken probation didn't necessarily, the recidivism rate was much lower than on these other people. And so I think across the board, what they were looking at is how do we stop that?
Mm-hmm.
And so that's why kind of this, you know, and you're talking about, I mean, really, a drug case,
Right.
less than a gram case, you're talking about a third offender theft.
Repeated thievery.
Right. And you're talking about a forced prostitution.
Right.
I mean, these are not crimes that you say, hey, you know.
Right. Will the judges or that court still be using the same evaluation tools like the TRAS and things?
No.
Okay, so what's the deal with that?
Okay, I don't totally understand it.
Okay.
So you're asking me, like, did y'all have interviewed me in 3 weeks or 3 months?
Which she said it on the air. In 3 months, we're booking
Promising
Staci
to come
Biggar.
back
She's
with a
coming
lot of
back.
information.
We're going to talk about integration court. It's done. Perfect. Thank you. Good night, ladies and gentlemen. No, but so are they going to be? So what's your idea on the same tools or not same
It's
tools?
supposed to be, because you know the TRAS takes for however long, and then the CAS takes even longer than that. And I forget what the acronym is for the tool that they're supposed to be using, but it's supposed to be a faster tool, and so that you can see what sort of services and so forth. I do know it's Judge Bradley and Judge Brown that are doing the court, and I do know that at least initially they're going to rely heavily on that. So I've been told that there are supposed to be programs that will be available to go into that. However, I want to see what those programs are going to be. I mean, for right now, like the dual diagnosis rehabilitation program, that would be if you had a mental illness and a drug problem, which quite often those go hand in hand.
Are those inpatient?
No, it's in custody. So it's
Right.
the program that they have, but it's in custody. Right now, it's like a 3-4 month wait to get in.
Right.
So that's not what it's my understanding that that's not what that program is looking to do. So I've been told that there'll be, you know, other programs available and so forth. I don't have to do it to
Right.
find out what that's going to be.
One of my just initial thoughts are, if more people end up on bond through either bond reductions or personal recognizance bonds, and the tool they use recommends in custody treatment. So currently we have, like, you know, the HUA or HUE and
Right.
the WHO and PEDIN and these kind of things. I have found that it's difficult either in custody
It's a
or
hard sell. Is that what you're saying?
It's what?
It's a hard sell.
It's a hard sell. Like I mean, and usually, and even the people in custody, sometimes they kind of realize if because it's a felony, they know 6 months to 2 years, the kind of scenario they're looking at, and they could do that now and get in the hua and do that what they need to do, and then they get that sometimes. But also the people on bond, and so the kind of thought is that these individuals who are now on bond, they take an evaluation or use some tool that's going to require them to go back into some sort of custody treatment or inpatient. Right. Do you know anything about that, or do you?
I mean, at this point, I don't really know what all programs they're looking to do. Mm-hmm. So, I mean, if I know that we have my experience in the other courts that I work in is that I know that we have long waits and very few beds. So I would have to think that you're going to have to do more intensive outpatient than, and I, I'm sure the evaluations are going to say that they need, some sort of residential treatment. Right. But whether or not the bed availability is truly there, because I think that the point is to try to get it, to address the problem as quickly as possible. Right. So, but I do know, I mean, they've had a lot of collaboration with the community for different things. So you are looking at VA services, if you're a veteran, different places that you might be eligible. Maybe MH or the Harris Center is now the MH market.
Well, I'd like to officially announce that the JV Center for the Reintegration Court Bed Facility will be up and running. And Ed Emmett, I'm sending you the bill. No? Okay, so let me ask you this, though.
Let me take a break.
Take a break.
Thank you.
Get a word in it.
It's great. This is so much information.
We're opening up our phone lines right now, ladies and gentlemen. 713-807-1794 is the number. Call in with your questions for Staci, Julio, and myself. We also have Twitter up. It's been real silent up here right now. So at HCCLA_TV. We got that at the bottom of the screen, too. I want to switch gears a little bit, but it ties into what you're talking about with the reintegration court. Recent study just came out and said there's 6.1 million disenfranchised voters in this country due to felony convictions. It's a staggering number. And the study goes through and it talks about, the different percentages and the escalation in it. And, there's only a few states. People are going to be surprised to learn this, but there's only a couple states that have actually allowed the, people to get their civil rights back and their voting rights back. I mean, it's crazy. And, Texas, you can't get anything back. You can't get the right to vote back. You can't get your gun rights back, nothing.
Are you sure? Because I thought that Texas, you could vote as long as you weren't on parole, probation, or currently in prison.
I believe you're right, Ms. Biggar. I
thought you had to make a formal petition in order to get it reinstated after a felony conviction.
I think, I could be wrong, but I think that as long as you're not on probation, parole, or in prison, you can vote.
But not unless you move formally to get it reinstated, right?
I don't think so.
Callers, for people smarter than us, please call in. And the only reason, not the only reason I'm going with Biggar, one of the reasons I'm going with Biggar because I am a lawyer, but the real reason I'm going with Biggar is because
she knows her stuff. She knows her laws.
Right, and that's what I'm saying.
I know, but I'm not asking.
So that's why I'm asking you.
I think yes.
Okay.
That's my final answer.
All right. Do we need to phone a friend?
Yes, we may have to do a shout out.
Phone a friend.
Judge Kavanis.
Yeah.
I saw you earlier, and you said you were going to Skype in.
Well, she said she'd save me.
Yeah, she's here. But Judge Kavanis, you said you're watching.
But that's kind of my point. Is if we can't figure it out, and we're not certain, as three lawyers sitting here at a table, how the hell are people supposed to figure it out? How are people who have been convicted of a felony, don't know, the first thing about doing this stuff, they just think, oh, well, you know what, I've lost those rights.
Right.
I'm done.
And I thought it was really interesting,
I'm not going to participate.
In the article, it said that 1 out of 40 in our population couldn't vote because of that. But 1 out of 7 African Americans couldn't.
Yeah.
And that's pretty amazing. So if they think that they can't because they previously had a felony that they were on probation or in prison or on parole for and no longer are, then the number has to be greater.
Yeah. Well, and what
It's
strikes
amazing.
me, what you were talking about earlier, is just the people who keep coming through the system and ragging up these numbers. And I wonder, when you look at the numbers of people, the disenfranchised voters, and we're talking about this reintegration court, it seems to me that we also need to educate them about how to reintegrate their civil rights. Like, you can be part of the process, you can do this, and here's the steps to get it done.
Well, so I will say, I don't know if you listen to Sarah Pepper in the morning, but
Who?
Sarah Pepper on
What you doing at the courthouse?
exactly. So
I was making sure.
I've heard of the show.
I know.
I was like,
So we listen every morning on the way to school, right? And so one of the things is that there was actually, did you see the people in front of the courthouse that were signing up voters, right?
If you're a felon, you can vote.
Right,
Yeah.
and so that was exactly what they were doing, and they were in front of the courthouse for 2 out of the 4 days we were been there this week, signing up voters, trying to explain to voters that they could vote if they, were no longer on papers, if they were not on parole, on probation, or currently in prison. So,
But here's the thing. Okay, so you come up, first of all, it's hard to make it to the polls if you're in prison, all right? So
I guess you could mail in your vote.
But you couldn't if you're in prison, though, right? You
could
can't.
theoretically mail in,
Right.
but
Yeah.
But I don't understand what disqualifies a person from voting if you are in prison or you're on parole or you're on probation.
Well, I think it's because that label makes you inherently dangerous to society. And
What does that have to do with voting?
Well, you can't make a decision.
That doesn't make
I'm playing
any
devil's
sense.
advocate here, but isn't that? What do you think, Staci?
I mean,
You're telling people they can't participate in the process. Isn't it enough that you've given them a felony conviction and probably saddled them with all the issues that you see through all these potential repeat offenders and now we're just now getting a reintegration court?
well, I will say, so one of the speakers that I heard earlier this week, she was a recovering alcoholic. She had been through some of the treatment that we do now, and this was 15 years ago.
Yeah.
And so one of the things that she was saying is that you never hear about the person who went into the system and recovered.
Right.
And that person's voice is never heard. So you have organizations that scream out, punish, 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 but very few voices that say, okay, wait, this may have happened to me 10, 15 years ago, but now I'm this person. And so why is nobody hear this voice? And so I think that plays in the same thing with the voting and so forth, is that how long are they punished for the crime that they committed?
Yeah. We got a phone call coming in. I want to take our first call of the evening.
Yeah, I have to ask. So you're saying that it's more dangerous to be able to vote as a convicted felon for whomever you choose than to not be a convicted felon and vote for Donald Trump?
Most of society has placed a stigma upon people who have felony convictions that they are more dangerous in casting their vote and are not qualified to be casting a vote. I think that's what, isn't that the policy behind that?
I don't know.
I don't understand the policy. I don't know that there is a policy. I get the caller's point. It's a cynical one. Like, wait, you're telling me that people in prison, they can't vote, but whatever your politics are, I understand the caller's point, but that's the thing. I don't understand why you think these people are not qualified to vote. Okay.
Because they're felons.
Again.
I'm playing devil's advocate here. Look, I'm playing devil's advocate here, though.
But
okay,
look,
straight up.
You cannot give me a valid reason. There's no one that can argue that. I can understand not reinstating someone's gun rights if they're a felon, particularly if they're convicted of a violent crime. Totally get that. Okay. So reinstating gun rights, I'm with you on that. Voting rights?
I don't know the legislative history behind it, but maybe they're thinking you would go and you would vote for somebody who was more lenient or wanted to change laws to make crimes you could commit crime. I mean, I don't know. I don't understand why you would do that.
But again, this gets to, here's the thing, and what people are going to say, and this is, I mean, well, whether they are or they're not, I don't know if they are, but here's what I can see is an issue when you look at the statistics about 1 in 7 African Americans. This is a further punishment on the African American community.
Correct.
Okay, because you are now basically inhibiting them or suppressing their right to vote.
Right, and that's why I believe that even under the impression that while I had a felony conviction, I no longer have that, I still can't vote.
Right.
Yeah.
That's the impression.
That's the impression.
That's the
that people
impression.
have. I mean, I had a client ask me today. He's like, "Can I vote?" And we were in court.
Really?
Yeah.
And did you say maybe?
No, I said you're on probation. You can't vote.
Ah. So who's leading the charge? Okay,
He wanted to know
so
if he could get arrested.
so let me.
But like, what does happen to you if you vote?
Well, if you go to the polls and try to vote, and you have a warrant out, you might get arrested.
If you have a warrant.
If you have a warrant out, you can go in the polls, you might get arrested. Okay, it's a public service announcement. But let me ask you.
I would venture to say I don't think the little old lady checking the driver's
Yeah, I was gonna say, who's gonna arrest them?
Excuse me, sir. We're gonna have to place
I
you.
know. The lady's
She's
like,
not gonna do a take. She's not
"Is
gonna
that
do
your
a take-
name? Is that your driver's license?"
She's not gonna do a takedown at the civic center. Not gonna happen.
Well, let me ask. Is the reintegration court something that is pioneering and on the cusp of
Yes.
criminal justice reform? And who's behind it? Is it the judges,
So
the
you
DA?
know that
What's the deal?
humongous thing that we all had to attend, that we were so bored at for 2 days, that we were in that back room. Okay, that was the MacArthur grant, right? So, so Harris County applied for funding to try to relieve and do jail diversion here in Harris County. We actually where we were granted the money, and so that's what that money is being used for right now, is for this program. Yes, it's very pioneering. There is not another program like this in the United States. If this program actually works, we will be the national model for it. So,
Wow.
talk to me in a year.
So, with it, how many cases is this court expected to handle a year?
They think 8,000 a year.
Is that proportional to what a district court would have anyway?
No, they don't have 8,000 cases a year. You know that.
Well, I do know that. So how is the reintegration court going to handle that?
I don't know. That's one of my questions.
Because you can't clone you 5-10 times. You're going to have a good, not only on the district attorney's, the state side, but you're going to have a good, defense
right,
part of it.
right.
Have they? So if everybody's expecting 8,000 new cases, which is
A
amazing.
lot of cases.
I mean, okay, so let's say you had 8 lawyers. That's
I think they
1,000.
have 20
Okay.
right now.
Okay.
I think there's 20. I don't know absolutely for sure. Right now, I think there's 20 lawyers. But like I said, we all went into it not knowing a lot about it. There's several other lawyers that are in similar circumstances that I'm in. I like this kind of thing. To me, I like trying to figure out something new, something different, something creative, something outside the box. Whether or not it ends up being successful, at least we tried.
Right.
So how do you make that puzzle fit? How does it work together in the end? I mean, I've been very fortunate in that I've been with the Veterans Court since inception. I've been with the Competency Restoration Court since inception, and I've been with Judge Ellis's CTI Mental Health Court since inception.
Wow.
So I'm excited about being
That's amazing.
with this since inception.
That's really cool. Imagine, respectfully, the amount of lives you've changed. We talked about it earlier, and we asked, oh, well, Staci's here, and you said, well, what can I do? But I can only imagine that if you've been successful in those 3, because your reputation does precede you.
Thank you. And Montgomery County Veterans Court.
And you're coming for another one, and I can only imagine the impact that you have. And,
Thank you.
it's one life at a time.
It is one life at a time. And that's why when I was talking about, when you first get to them, you need to sit and talk to them. You need to understand who they are and how they got there and what their path is. Now, I'm not saying you're going to spend but sit and talk to them. I mean, you and I have both been back there when people will go, you're charged with this, the offer's this, you take in there, you're not.
Right.
Right. And then I'm like, I mean, I've been hired on cases where the families were waiting for them to get arrested because we've been talking this whole time, we can't get them mental health services. I mean, I literally have a client, she hired me on 3 different occasions, and the second time she hired me on a Friday. He got arrested on a Thursday night. Saturday morning, she's eating her Cheerios, and he walked in the door. It's just like, somebody.
What's going on?
Yeah, she's like, he got put out to time served that morning and was out. And so, I know that sounds like a good thing, but nobody sat and talked to him and realized that he was severely schizophrenic and wasn't on any medication. There's no possible way he was competent when he pled on that case.
The idea is that you get him into this reintegration court first. So it's not like you get him into the 262nd and then they're transferred.
Okay, so what happens is everybody charged with this offense, regardless if you're a true habitual or a first offender, if you are charged with this offense, you will come to the reintegration court.
What's the screening process?
The offense.
Well, I get it, but how do they know that this individual?
So then it's supposed to be pre-screened. Like I said, I don't know, I start Monday.
Right.
So it's supposed to be pre-screened where, like, it could be that the district attorney's office already knows that they're going to offer you pretrial intervention.
Mm-hmm.
And so you have an idea coming in, but it's also going to be part of our responsibility to find out where they might fit in this. I mean, as you know, you come in, and quite often what's in the offense report may not match what your client says.
Right.
And so, you may need to.
I've never had that happen.
You've never had that happen?
Never had that happen.
So, after learning and talking, maybe you do need to get an investigator. Maybe you do need to check some things out. Maybe you do, and you're hoping that you can do that while they're out. But you also, while they're out, want them to be doing something. You don't want them to be using drugs.
Right.
And so one of the things is that if you're going to ask somebody not to use drugs, you also need to give them the tools not to do so.
Right.
So, trying to encourage them to go ahead and participate in certain things because they've been given opportunities that if they had been in another court, they may not get that opportunity. So it's trying to sell that side of it also. And maybe in the end, your outcome might be different.
Right.
But looking at the whole thing, I mean, it's like what you asked before. This is not telling somebody you have to go do that.
Yeah.
This is saying, okay, well, where do you fit in this? And let's see what we can do, not to bring you back into the program, or into the courthouse.
Let's get to another call here. Hello, thanks for calling Reasonable Doubt.
Hi, thanks for taking my call. I wanted to take it back to your voter disenfranchisement commentary earlier, and wanted to ask if any of the people on your show tonight, or if you guys have read The New Jim Crow by Professor Michelle Alexander, where she compares earlier forms of social control to the current criminal system, mass incarceration, and voter disenfranchisement, and the history of voter disenfranchisement being used to punish since the start of democracy. I'm just interested in hearing what you guys might think about that. And then also wanted to ask a question for Ms. Biggar. She mentioned that she works in the specialty courts. Just curious, how does a defendant contact or reach out to you if they want to get into one of those courts? How can they find her? How does that work?
Thanks for the call.
I tend to agree, and before we answer, there's oftentimes I get appointed to clients where I say, this should be Staci's client. Straight up. And so I reset them, and I try to send them to either the PD or with mental health issues, and if it doesn't work, then I try to sit down and treat the case as how it should be treated.
Right.
So I'm with the caller. How do I get them to you, Staci Biggar?
So, okay, so a couple of different things. I mean, it depends on what all the programs that I work in are felony court programs. So I've done some misdemeanor this year, but I don't do a ton of misdemeanors. So on the felony court side, if you're a lawyer, then ask the probation officer. Most of the time, the probation officer is gonna have the applications to the program